All right, good morning. Welcome to our first official day of oral arguments for the term. We did hold oral arguments in September up in Marquette. We had a wonderful time up there and great arguments, but we're excited to be back here in the Michigan Capitol where the Supreme Court historically sat in this room. We come back here for our first case call of the term, with the exception of a couple years where there was some renovation and COVID. So we are excited to be back here again this year to kick off the term. We want to say a special thank you to Senator Anthony and several of her staff members, Adam and Christy, for all of their assistance with getting us over here today. So our case today is Hark Orchids versus Buie. This is a mini oral argument on the application. You both have 15 minutes. You may reserve time for rebuttal, but we ask that you keep track of your own time if we do not use it up. And you may begin when you're ready.
Thank you, and may it please the court. John Turk on behalf of the appellant, Hark Orchids. I understand that I may sit while presenting, and I appreciate that. I, of course, mean it as no sign of disrespect to the court. I am embarrassed to say that this is the first time in the state capitol building since I was the age of the students behind me. I am thrilled to be here. I'm honored to be in your and their presence, and I feel a bit more pressure than I otherwise did, knowing that the students are behind me, and so I hope to acquit my client's cause well. To do justice in this case, I think we must start at the beginning, which is to recognize that the purpose of tort law for more than 150 years in this state is to attempt, as best as our system of civil justice can, to put the victim in the position he or she or it would and should have been but for the tortious conduct. Victims of legal malpractice who are required to spend money to undo, to mitigate, to lessen the effects of the malpractice ought to be able to recover those fees and costs of mitigation. That's at its core what this case says and why the application was filed. The technical, dare I say, egg-headed appellate law argument that Miris does not control is found within the supplemental brief, and I will rely on that briefing, except, of course, subject to any questions your honors may have for me. Miris doesn't control this outcome on that point because this court overruled Miris, rendering what the Court of Appeals said on that point of no precedential binding weight, of no precedential binding authority. The prior litigation exception in Allen, 1973, got it right, got it dead on. I think it's critical to recognize that attorney fees, as they apply to the American rule, occur not only in the so-called present litigation, but they also occur in prior litigation or other litigation, as I think is the more accurate term. I want to be clear, my client does not seek my attorney's fees in connection with this present action, if I am fortunate enough to be successful, if my client is. What they seek to recover are those fees and costs of mitigation they were required to pay to other attorneys to undo, to the extent they could, the effects of what we say was the appellee's, the defendant's, legal malpractice. The case law on which Miris rests was relatively clear. Miris, with respect to that court, went off the rails in its analysis by merging two exceptions which until then had run in parallel tracks: the prior litigation exception and the malicious, fraudulent, similarly wrongful conduct exception. For purposes of collecting fees in the present litigation, I acknowledge that the American rule bars my client from being able to do that, absent a claim that the defendants acted maliciously or fraudulently.
So does your position create a legal malpractice exception to the American rule? Or do you view it as just changing how the prior litigation exception is applied?
The latter.
Okay.
The prior litigation exception actually worked well and should, I think, and would work well in the legal malpractice case context, because what Brother Counsel says in his papers is essentially, well, if the court changes how we treat these expenses of mitigation now, the floodgates of litigation will open. I respectfully disagree, not only because, again, in service of that original goal of tort law, which is to put the victim of the tort in the position they should have been in, but for, all of the guardrails that apply to any other item of damage will still apply here. The plaintiff in the legal malpractice will have to prove the familiar elements of a tort: duty, breach, causation, and damages, fact and extent of damages. And much in the no-fault case context, and this is not a no-fault case, thankfully, but it's a concept that will be familiar to the court and to the bar in terms of proving reasonableness. Were attorney fees reasonably incurred by the plaintiff to mitigate the damages? Were the attorney fees incurred reasonable in amount? That's all fair game for defendants of legal malpractice cases to argue. And they are the guardrails that are familiar to all of us who labor in the field of civil litigation in this state. Those are unchanged. Correct. And what I would say is, if you look at Allen, I think Allen got it right on the money. The restatement of torts, section 914, which you will find in my supplemental brief, says it as well as I can, and I won't. A person who through the tort of another has been required to act in the protection of his interest by bringing or defending an action against a third person is entitled to recover compensation for the reasonably necessary loss of time, attorney fees, and other expenditures thereby suffered or incurred. That's a fine way of thinking about it, and is in essence what the Allen court recognized at that point was the prior litigation exception. The problem was Mieres merged these two. And since then we have not had, as I think everyone in this case, all counsel agree, we do not have a clear ruling from this court on the issue of that prior litigation and on one hand, and the malicious wrongful conduct exception on the other hand. The malicious wrongful conduct applies to fees in the present litigation. The prior litigation, as the name plainly suggests, refers to fees incurred in prior or other litigation. This case, again, does not seek fees in the present litigation. Those are off the table, absent allegations of fraud, maliciousness, other similar wrongful conduct, or unless a court rule or law otherwise provided for their recovery. Not sure that it's germane to this particular argument, but I know of none that would apply here. And so what Hark Orchids is about is that prior litigation exception, because they say we were forced to spend more than $300,000 of attorney's fees to fix a problem that should have been nipped in, and would have been nipped in the bud, but for the alleged legal malpractice.
But must we overrule Mieres for you to win, or is it a case where we can look at that case and find distinguishing factors and clarify the law?
You do not need to overrule Mieres. Mieres' analysis is muddied. I believe this court's explanation of why that's so would be hugely beneficial, as it would apply specifically to the issue in this case. Mieres is not binding, again, for the reasons I've articulated in the supplemental brief. The key reason among them that this court overruled Mieres on other grounds, the result of which was that the Court of Appeals' decision, in Mieres, thereby lost its precedential weight, binding authority. There is also, Your Honors, a duty issue raised in the motion for summary disposition. I can't read minds, of course. You have my position on that in the supplemental brief. The trial court did not address that issue because it was moot, having decided what it did on the attorney's fees issue. The Court of Appeals similarly did not rule on that issue for the same reason. I do not believe that issue is ripe for review. I would not want you to think that I had abandoned that argument by not raising it here. It is in my supplemental brief. The short and sweet argument on that point is simply, this was a C8 motion. The complaint, plain as day, alleges that there was a duty and that there was a breach and that resulted in damages to my client. That all, of course, would have to be litigated in the trial court, but to do that, we'd need to get to the discovery phase, and we weren't even close to finishing that at the time. The trial court dismissed the case, again, on the attorney's fees exception. I have lost track, candidly, of how I am on time.
You have 5.5 minutes.
I would only be repeating myself if I continued further. I will rest, if you will, and defer to brother counsel.
Thank you.
Thank you.
May it please the court, David Saperstein on behalf of the defendant appellees, and I would share the just joy of my brother counsel to be in this building, to have this audience here today, and it's just a magnificent building, magnificent room, and I thank the court for allowing us to be here. It's a real honor. 3 points I'd like to make that were addressed in the appellant's supplemental brief. I'll address them real quickly. One is this State Farm v. Allen case. I have it in my notes as State Farm. He's been referring it as Allen. It's the same case. There were obviously dozens of cases that both sides argued in our briefing. I did not certainly mean to omit the State Farm case. And when you look at that State Farm case, which is so instrumental in the argument today, I would make 3 points. Number one, that case relied on a treatise, McCormick treatise, that was last updated in 1952. It is not current today. The second point is it's not a legal malpractice case. One of the appellant's criticisms of many of the cases that we presented was, oh, these aren't malpractice cases. Well, when it suits the appellants, they have also cited many non-legal malpractice cases. So that is the second point I'd want to make. But most importantly, in that State Farm case, there was a trial, there was a verdict, and the jury specifically found that there was fraudulent conduct by the defendant. The court did not go on to address the quantum of proof for the prior litigation exception, but that case is absolutely consistent with the long-standing line of Michigan cases which says to get prior litigation there has to be fraudulent or malicious conduct. It was there, the jury said that. Second point I'd like to make real briefly is a concession. One of the cases that we cited was a case out of Texas called Goldman, which upon rereading and after reading the appellant's reply brief, I believe they are correct. And that one did not involve prior litigation, so we would withdraw our reliance on that one Texas case.
You argue that applying the repeating, or however you want to say it, applying the fraud exception is appropriate because that there are heightened standards required in this kind of case, right? And what was questioning to me is that in other circumstances where there's a heightened standard, such as governmental immunity or other, the Recreational Use Act, there are reasons why. There are other interest policy reasons to require that heightened standard. What is the reason why a heightened standard is here, other than just to make it harder to sue lawyers?
I'd say there's two prongs to that. Number one is the reason for a heightened standard has not to do with legal malpractice particularly, but it has to do with the American rule itself. The American rule itself is in derogation or of the public purpose or the policy purpose of compensatory damages. What courts around this country have always held, and Michigan is no exception, is that attorney fees themselves are a different kind of damage for which there should be some kind of heightened standard. And that's why the legislature has said, in the examples you raise, Justice, that, governmental immunity, there's this heightened standard, some of the other cases. And there's statutes that say, in these kind of cases, attorney fees are allowed. That kind of statute does not exist in the legal malpractice realm. But the second point is why legal malpractice specifically? And I think both sides are actually in agreement on this, that it doesn't make sense to have a legal malpractice exception. You look at the cases cited by plaintiff, almost all of the Michigan cases are not legal malpractice cases. And there's two exceptions, and both of them are defense-friendly, that being Mieres and Coates. So in this case actually gives one of the best examples of why there is an American rule, and that is this. The successor counsel got this case and allegedly found out for the first time that there had been this prior settlement demand. They had less than $10,000 into the case at that time. They then did not report that to their client. They proceeded to spend an additional $300,000.
So counsel, that may, I don't know whether that happened or not. Isn't that something that would get worked out later if we find there's enough to at least move forward with the claim? That sounds like C10 territory versus C8.
I don't disagree. But I think it does go to the public policy.
Okay,
question.
well, explain it. So I'm interested in that public policy argument. Obviously, for the benefit of those, there's lots of other people in the room today. The American rule says normally attorney's fees are not recoverable. In Europe, different. If you lose in a lot of countries, you get your attorney's fees. In the United States, it has to be authorized by statute. So here, we have this unique situation where the actual damage alleged is malpractice, not something else where the lawyers are paid to move the case forward. But I'm just thinking about if I have my water heater breaks and I have a plumber come out and he messes it up. He makes it worse. It breaks, it floods. So I have to pay someone else to fix the water heater. I would assume my damage would be the amount to fix the water heater. Why is it any different for attorneys who potentially, allegedly mess up the case?
I think it's different anytime attorney fees are involved, because attorney fees are people can sue for anything and any reason, whether it's a good reason or a bad reason, whether they can win, whether they win or lose. And when attorney fees become become available, that incentivizes a party to sue their attorney, as in the cases that have been presented, where even if they won, even if the attorney's conduct was affirmed by the court in the underlying case, now they're being sued for
Well, that would seem to get to the reasonableness of the fees and if they were properly incurred. And of course, if there's abuse there and the billings aren't appropriate, that seems like something the lower courts would work out, which happens all the time in attorney fee statutes. There's a big battle about that. So I don't see that being very different.
Is not your response to Justice Welch really your claim that the American rule, it's the American rule that governs this result? Isn't that really what you're saying?
That's exactly what I'm saying.
But aren't the policies and the purposes of the American rule satisfied in this case by the fact that that attorney is not looking to collect fees to get this case? That's what the American rule is all about.
The American rule, as it's been applied to Michigan, has applied to both. This would be...
What case law is there in Michigan that says that?
If you'll...
I know there's a lot of other jurisdictions that would go the way appellant is advocating, and a lot of treatises. I'm not a big fan of law professors from other jurisdictions telling me what the law should be, but it seems to me the law from other jurisdictions and all the treatises go in the appellant's favor, and I haven't found anything in Michigan that goes your way. So it seems to me to be an open question.
I would respectfully disagree, Justice, because the treatises I found, the restatement second of torts that was cited by appellant today, imposes a tender requirement. So does the Amjur second damages. There is a tender requirement in those treatises. I have not seen the treatise that says there's no heightened standard at all. And perhaps it exists. I don't claim to be a scholar that has, written a law review article on this issue, but the treatises I've seen do have that tender requirement. There's a lengthy line of cases that were cited in our briefing where there is a prior litigation exception. There's no fraud or malice required, but there is this sole cause. And in all of those states, the Third Circuit, Pennsylvania, Minnesota, North Dakota, Washington, Fourth Circuit, Nevada, Massachusetts, all of them say that the prior litigation has to be one where the defendant's conduct was at issue. And that is not the case here. And then there's the cases.
It's always going to be the case in a malpractice action that there is some alleged conduct against, in this case, Hark Orchids, right? I mean, like, that's the nature of why they had to defend in prior litigation. Here, it was an allegation of employment discrimination or whatever it was. I mean, so it's never going to be solely the attorney's conduct, right? Because there's an allegation against the client.
I believe never is too strong. I mean, there is a case that was cited where there was fraudulent conduct of an attorney that was at issue. And in that kind of case, that would satisfy it.
Can I ask you a little about the tender rule? Like,
Sure.
how, I understand your point, but in practically speaking, like the example here, you had an attorney, your client was hired by their workers' comp carrier to defend the comp claim, right? And they're paid by their insurance carrier. Their scope of representation is limited to that, right? This is outside of it, and I mean, it's somewhat unique. They're not alleging that there was malpractice in defending the comp claim, right? It's this other claim that supposedly existed and should have been related back to the client. But so if the successor counsel, you say, should have tendered that to the comp attorney to defend something that a comp attorney is, one, not going to typically defend, but also there isn't coverage, I would imagine, for that. Like, I mean, how would that work in this circumstance?
Well, the way it works is the same as it would work in any tender context. And many types of claim, not many, there are tender requirements in the law, and those apply not to lawyers. So if you're ABC Corporation and a claim gets tendered to you, it doesn't mean ABC Corporation is going to defend that suit. In this case, if my clients were tendered the claim and actually defended it themselves, that could be a problem. That could be a separate problem. What would happen in that instance would be either they hire outside counsel to defend or perhaps negotiate a settlement, or what is much more likely is the lawyer defendant who's tendered the claim then tenders it themselves to their insurance carrier who would hire outside counsel. I do want to briefly address the duty issue. The order of this court said to address issues of whether summary disposition was granted. I understood that to mean that the court was asking for arguments on duty. I absolutely agree this was not decided by the trial court or the Court of Appeals. I believe for the reasons that we state in our brief that the duty is a separate, independent argument that can be decided at this stage to affirm the Court of Appeals decision on alternate grounds. If there's no other questions, I would urge this court to affirm the Court of Appeals and preserve the heightened requirement that is currently required under Michigan law for prior litigation.
Thank you.
The critical distinction that gets lost when talking about the American rule, or that has gotten lost in a few previous decisions in Michigan, is the failure to recognize the difference between present litigation fees and other litigation fees or prior litigation fees. Justice Welch used the example of a plumber. You could change that to any one of different situations. An assault on the street, which causes the victim to incur medical bills. An accountant who mishandles a tax return, the client then has to hire successor accountant help to file an amended return. The victim of a legal malpractice claim, a victim of legal malpractice being required to hire another lawyer to mitigate his or her damages. Whatever trade or profession we attach to it, they all ought to be treated the same. If they are forced to incur fees and costs to help fix the problem, to minimize the harm, as this court should want every litigant or potential litigant to do, then we ought not give them a disincentive to doing so by saying to them, well, the plumber example, the homeowner gets to recover her fix-it plumber fees. The accountant client gets to recover his or her fix-it accountant fees. But you, Mr. or Ms. victim of legal malpractice, you don't get to recover the fees you paid to your fix-it lawyer to help solve the problem. That should not be the policy of the state. That is not the policy of the state. And that's why I believe that State Farm versus Allen, which I agree was not in the context of legal malpractice, but it clearly talked about present litigation fees and prior litigation fees, recognizing the two differences. That court got it right. I recognize Justice Zara is not a fan, shall we say, of the treatises, and I respect that. My suggestion that you look at what the restatement has said is obviously only a suggestion by me, but I think that's not so bad a way of thinking about, in my respectful submission, what an appropriate law would be. I am not asking the court to overrule or set aside the American rule. The prior litigation exception works fine. I think it ought to apply to other professions. We are here in this legal malpractice case context, and of course you will decide, of course, what you think is right, but that public policy interest, I think, is the real main one driving that should drive this court's decision on the application. And I think I've been clear in my brief on the duty issue. I worry about, though, the risk of being unclear. My client does not say that this law firm had a duty to defend an employment discrimination claim. We merely say that the lawyer, when that claim arose in the context of a comp proceeding, plain as day, on page 1 of the other side's mediation statement, had an obligation to pass along that settlement demand to the client. What the client did with it would then have been up to Hark. Hark would have been wise to go to other counsel if their comp counsel said, look, that's not really what we do. You need to hire employment lawyers to defend.
Can I go back to, I think what you were saying before. Do you think that we need to overrule Miras, or you think that has been done and we don't need to do anything with Miras?
I do not think you need to do anything with Miras. The Court of Appeals decision in Miras lost its precedential value when this court overruled Miras. So for that technical appellate law reason, I think this court...
Didn't the Court of Appeals apply Miras in this case?
Yes, it did. And that's why
You just think that we need to
well,
clean that up, or?
Yes, whether it's a technical overruling or not, I defer to you. You are smarter than me on these things, of course. I acknowledge the Court of Appeals relied on Miras. I don't think it should have, but I don't wear the black robe, and I didn't have a vote on those things. And so I just think Miras' analysis is muddied. It merges those two lines, the prior litigation and the malicious wrongful conduct, in a way that had not done before. And it actually surprises me, having labored in these vineyards for 20 years of doing legal malpractice law. I'm surprised actually this is the first time that this has arisen, but we are where we are. And so whether you consider, to answer your question as directly as I can, and I apologize, I do not think you need to. I think it would be helpful for this court to say Miras was wrongly decided. For whatever precedential value anyone thought it had, it does not. This is the rule going forward, at least insofar as it relates to legal malpractice claims and costs and fees of mitigation.
Thank you.
Thank you very kindly.
Thank you both. The case will be submitted, and the court will be in recess until 10:30, where we will reconvene at the Hall of Justice. Thank you.